Hi, this is Professor Moore, and here is the long-awaited YouTube review of personal jurisdiction video. Now, the last video covered the so-called traditional assertions of personal jurisdiction, such as personal delivery of a summons and complaint in the forum state on an individual defendant. Here is the website for that video. This video is going to cover the more common assertions of personal jurisdiction, or at least the more common ones that are challenged, and that is for specific jurisdiction and also for general jurisdiction. So the overall framework for analyzing a problem like this has two parts to it. The first part is that there has to be statutory authority for the court to exercise personal jurisdiction over a defendant. And once there is statutory authority, then the second question is the exercise of that statutory authority by the court constitutional under the Due Process Clause of the 14th Amendment? Going back to the statutory part, the statute that you look at first depends on whether you're in federal district court or some sort of state court. If you're in federal district court, which in our class we usually are because we focus on federal civil procedure in this class, the place that a federal district court starts is Rule 4K. If you are in state court originally, then the place where the court starts is the long-arm statute of that particular state. So looking at being in federal court first, again, that federal court for statutory authority is going to technically begin with Rule 4K. There are two parts to 4K. 4K1 is what you will normally be looking at, and in particular you'll normally be looking at 4K1A. And it says serving a summons or filing a waiver of service. Now you know what that means because we just learned about Rule 4D last time. Establishes personal jurisdiction over a defendant, A, who is subject to the jurisdiction of a court of general jurisdiction in the state where the district court is located. All right, well, that's a really roundabout and confusing way of saying that the federal district court can simply look to the long-arm statute of the state in which the federal district court sits. And when 4K1A uses the phrase court of general jurisdiction in the state, they're not talking about general jurisdiction in the sense of personal jurisdiction. The phrase is hearkening back to the use of the words general jurisdiction when we use that in terms of subject matter jurisdiction. So you remember that state courts have very broad subject matter jurisdiction, and so essentially what this is saying is that when you're in a state court that has broad subject matter jurisdiction, look at what that state would look at to establish personal jurisdiction. The other sections of 4K, namely 4K1B and 4K1C, are not things that we've looked at very much, and we will come back and look at 4K1B more specifically when you actually learn what Rules 14 and 19 are. I don't think that's going to be very meaningful to you right now. The other part of 4K is 4K2. Now, if you don't read this carefully, you might think that 4K2 actually applies in a lot more situations than it really does. So 4K2 applies to federal claims only, so for a claim that arises under federal law. So that's number one, is that kicks out a bunch of diversity cases. Serving a summons or filing a waiver of service establishes personal jurisdiction over a defendant if A, the defendant is not subject to jurisdiction in any state's courts of general jurisdiction. So what that means is if the defendant, if you look at the defendant's contacts with all of the states of the United States, and the defendant's contacts are not sufficient to subject it to jurisdiction in any one state. But if you look at the defendant's contacts with the United States as a whole and treat that as if it just were one state, it may be that those contacts are sufficient to subject the defendant to personal jurisdiction. And then, of course, the second part is that exercising such jurisdiction would be consistent with the United States Constitution and laws. So that's the due process part of it. The reason that this provision was enacted was to close a loophole with respect to defendants from outside the United States, where they might not have enough contacts with one individual state to satisfy the minimum contacts test, but that if you looked at the United States as a whole, the defendant had enough contacts with the United States as a whole to satisfy the minimum contacts test. Again, this is a rarely applicable provision. So most of the time, looking at Rule 4K from the point of view of the Federal District Court, you're going to end up at the state long-arm statute through the provision of Rule 4K1A. If you were starting in state court to begin with, you would just start straight at the state long-arm statute. So from here on, the analysis is the same, whether you're in federal court or state court. So there are two basic types of long-arm statutes. One is the enumerated type, and the other is the type that simply says we go as far as the Constitution allows us to go. So as you know, Florida has an enumerated type of long-arm statute. So if that's the case, then you need to identify which of the subsections of the long-arm statute best fits the situation that is being described to you, whether it be a hypo on an exam or an actual case in real life. I'm not going to reprint the whole Florida long-arm statute here. As you know, it's very long and has many different subsections. It may be that your situation qualifies for the assertion of jurisdiction under more than one provision of the long-arm statute. You're not limited to just one. I would emphasize that you recall that the lead-in for the section on specific jurisdiction, which is subsection 1 of this statute that you see in front of you, requires you not only to identify the act that is described in the subsection, such as for 1B, committing a tortious act within this state, you have to link it to that lead-in, which says for any cause of action arising from the doing of any of the following acts. Now, as you'll recall, that is the phrase that creates specific jurisdiction, because what it's saying is that the act of the defendant or the contact with the defendant into the forum state is what has given rise to the plaintiff's cause of action. So don't forget, that connection that needs to be made if you need to talk about the Florida or any other enumerated long-arm statute. It will probably have a phrase like that within it. Now, just a tip for exam writing, if, as you know, there are, I don't have it in front of me, but there are, 10 different subsections under this Florida enumerated long-arm statute, and you certainly don't need to go seriatim through the sections and tell me whether or not each one applies. So just focus on the one or more that have, a reasonable chance of succeeding as an exertion of jurisdiction under that particular provision. Here's the type of long-arm statute that reaches to the full extent of the Constitution. So say this is the California long-arm statute. I haven't looked it up recently, so I'm not sure this is exactly how it's phrased, but it's going to say something like, this authorizes the court to exercise jurisdiction on any basis not inconsistent with the California or United States constitutions. So that's the first general part of the analysis, is that the court needs statutory authority under the long-arm statute. Now, hypothetically, you could have a situation where you would look at the long-arm statute and say, there's nothing in this long-arm statute that even authorizes the exercise of jurisdiction. So in other words, the answer to the first question, in your opinion, might be no, there's nothing in the long-arm statute. Of course, as a theoretical matter, you would be done. You don't need to reach the Constitution if you don't even have statutory authority. Now, either for exam writing purposes or in real life, it would probably not behoove you to stop at that point, even if that is your considered opinion. You would then go on and say something like, even though I don't believe there is any provision of the long-arm statute that authorizes the exercise of jurisdiction here, on the assumption that there is one, I'm going to proceed to the constitutional analysis. So that's going to be your backup, fallback provision. All right, so now we go ahead and we tackle the part of the personal jurisdiction analysis that falls under the United States Constitution. Now I need to stop here and address the perennial question always asked by my students in a somewhat whiny voice: do we need to know the names of the cases when we discuss personal jurisdiction, or indeed any doctrine that includes United States Supreme Court cases? And I can understand why you might want to know this in relation to your other professors in contracts and torts and property, who may be telling you, you don't need to cite the names of the cases we've read when you write your exam. But if you think for half a second about it, you will realize why civil procedure is different from contracts, torts, and property. That is because when we're studying federal civil procedure, the decisions of the United States Supreme Court are actually the binding law whenever we are considering a question that arises under the United States Constitution, such as the constitutional part of the personal jurisdiction analysis, the 14th Amendment. Any question that arises under United States statutes, such as what does 1332, the diversity statute, mean when it says this or that, or any question that considers the interpretation of the federal rules of civil procedure. For any of those issues, the word of the United States Supreme Court is the final word on the matter. When you are reading a case in your contracts book, for example, it's going to be a case that the casebook authors have chosen as, a good example of this aspect of this particular doctrine. Or if there's a doctrine on which the courts go several different ways, here's an example of a court that goes this way. So, in other words, they're just examples of different ways of thinking or different doctrines, and the only place that those cases are binding is in the state in which that case was originally issued, and it may not even be binding anymore because it might have been overruled. These United States Supreme Court cases that we've been reading are binding in every federal court across the land, and if it refers to a United States Constitution point, such as the Due Process Clause, it's binding in every single court in the United States. So, yes, you can't really talk about the law unless you know the names of the cases, because the cases are the law. So it's not just, oh, Professor Moore is, a picky you-know-what. It's that this is the law. So if you want to see an example of this, if you were actually going to write a brief on personal jurisdiction in real life, just go to the Twen site where I've posted some of the briefs on Usher's motion to dismiss for lack of personal jurisdiction in the Copeland case, and you will see that the parties in that case, when briefing personal jurisdiction, cite a lot of these cases in making their arguments as to what the law is. Now, do you need to know the full name and the full citation on the exam? Well, of course not. You can just call it the Burger King case, the Asahi case. You don't need to give me, the names of both of the parties. You certainly don't need to give me the numeric citation. Even if in the stress of the exam you forget the name of the case, if you say something like the case where there was a Burger King franchisee in Michigan, of course in that case you would have remembered Burger King, but I was just using that as an example. But yes, you need to use the names of the United States Supreme Court cases that we have read to the extent that they are applicable to the questions asked on the exam. All right, so after that tirade, and getting back to the due process inquiry of the personal jurisdiction analysis. As you know, the starting point for the modern inquiry is the International Shoe minimum contacts test, this famous language that's quoted in every subsequent opinion and every brief from the International Shoe case that, quote, due process requires only that in order to subject a defendant to a judgment in personam, if he be not present within the territory of the forum, he have certain minimum contacts with it such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. Okay, so what this first brings up is, I said that the modern inquiry begins with International Shoe. This should answer your question that I'm frequently asked, should we start with Pennoyer versus Neff? Well, no. Many parts of Pennoyer v. Neff have been overruled by subsequent activity in the court. So on an exam, you are normally asked a hypothetical that is going on today, and it asks you, as of today, how should the court rule on this motion to dismiss for lack of personal jurisdiction? Well, if you were a court ruling on such a motion today, you certainly would not begin your analysis with Pennoyer versus Neff. You would begin it with International Shoe. All right, so getting back to this idea of contacts, I have another sort of caveat that I'd like to express. Of course, we're talking about the defendant's contacts with the forum state, the state where the lawsuit has been filed. Now, your casebook authors tend to take the position that if a contact by a defendant has not been purposefully caused by that defendant, then it isn't even a contact at all. So, for example, in the World-Wide Volkswagen case, the only possible, quote, contact, end quote, of World-Wide Volkswagen with the state of Oklahoma was the fact that a car that it sold in New York made its way into Oklahoma, and the gas tank exploded upon a rear-end collision, causing injury to the plaintiffs in Oklahoma. So there's only one possible contact that the record contained. Of course, you know that the court held that that contact was not sufficient because it was unilaterally caused by the actions of the plaintiffs in taking it into their minds to drive that car from New York through the state of Oklahoma. And in no way were the defendants, World-Wide Volkswagen and Seaway, responsible for that decision. And so it is true that the court in Worldwide characterized those defendants as having no contacts with the state of Oklahoma. And that's the interpretation that your casebook authors have put on that, that's not a contact. Now, while I can see where they get that, and that's entirely accurate as far as a reading of World-Wide Volkswagen goes, I think it's confusing to the student to censor yourself in that way when you're at the very beginning of the analysis and you're trying to figure out, well, what are the defendant's contacts with the forum state? I think it makes more sense to just brainstorm and get every single possible contact out on a list so that you can then analyze the nature of those contacts when you get to the other parts of the analysis. So for me, I would, and you know your opponent is going to be saying, in this case the plaintiffs is going to be saying, you know, this is a contact with the state of Oklahoma. They sold a car, it went to Oklahoma, it blew up. How could that not be a contact with Oklahoma? So for me, it just makes more sense to list all the things that are potentially contacts and then go on to the analysis rather than looking at it and saying, well, that's not a contact, so I'm not going to put that on the list. All right, so as we're thinking of these contacts, that's of course the first thing you're going to do is make a list of, well, what are the defendant's contacts with the forum state? And after you get those all written down, the first thing you should think about is, does the plaintiff's claim in this case, does the cause of action in this case, have some kind of relationship to the defendant's contacts with the forum state? And the claim might have some relationship to some of the contacts, but not with others, etc. But the reason you want to first think about the relationship between the plaintiff's claim and the defendant's contacts is that this is the distinction between specific jurisdiction and general jurisdiction. So the answer to this question of whether there's a relationship between the plaintiff's claim and the defendant's contacts is going to direct you in the way that you proceed next in terms of, are you going to talk about specific jurisdiction or are you going to talk about general jurisdiction? So the courts use different terminology to describe this possible relationship that might exist between the plaintiff's claim and the defendant's contacts with the forum state. Sometimes they ask whether the claim arises out of those contacts. Sometimes they say, does the claim relate to these contacts? Sometimes they say, does the claim have a nexus with the contacts? So they're all getting at the same idea, the relationship between the claim and the contacts. And as we learned in the book, if this is an issue, if it's not really clear whether the plaintiff's claim has a relationship to the defendant's contacts, the courts have applied two primary tests to determine this, and there's not complete agreement on which of these tests is appropriate because the United States Supreme Court has never actually ruled explicitly on this. But the two primary tests that are used are the but-for test and the evidence test. So the but-for test asks, would the plaintiff's claim have even arisen if it had not been for this contact by the defendant with the forum state? So, but for the contact with the forum state, would the plaintiff's claim have ever arisen? And the evidence test is the following. Does the defendant's contact with the forum state actually provide evidence of the plaintiff's claim? So the example that was used in your book was gosh, I forget the way it went. I don't have my book in front of me, but there was some kind of a resort in Alaska that advertised in Massachusetts, I believe it was, and a company that was looking to have its employees go on a retreat saw this advertisement about the place in Alaska and about how great it was, and sent its employees to this resort in Alaska. And when they got there, the resort was not at all as it had been advertised, so the advertisement was fraudulent. So they sue in Massachusetts for fraudulent advertising. And in that case, the contact of the defendant with the state of Massachusetts is the fraudulent ad that's gone into Massachusetts. So because the claim is actually based on fraudulent advertising, then that contact, the fraudulent ad itself, is going to be part of the evidence in support of the plaintiff's claim. So that would meet the evidence test. It would also meet the but-for test because but for the advertisement, the plaintiff wouldn't have gone on the trip and figured out that the advertisement was false anyway. Then if you change that hypo, so the defendant resort in Alaska advertises in Massachusetts, the company sees the advertisement, sends its employees to the resort, but now you changed the hypo so that one of the employees is seriously injured in the swimming pool in the resort. So now come back to Massachusetts, the injured party sues the defendant in Massachusetts. Well, now the contact with Massachusetts is still the advertisement. We don't even have to say it's fraudulent anymore. But the advertisement really doesn't provide any evidence of this claim for negligence in the maintenance of the swimming pool in Alaska. So no longer would the evidence test be met if that was the test you were applying. You would still, however, meet the but-for test because but for that advertisement, which we're saying is the only contact with Massachusetts, but for that advertisement, the company wouldn't have known about the resort in Alaska. the people wouldn't have gone to Alaska and the person wouldn't have been hurt in the swimming pool. So the but-for test would be met in that case, but the evidence test would not. Now, in a lot of cases, it is really very clear that the plaintiff's claim arises out of one or more of the defendant's contacts with the forum state. This is why the Supreme Court has never had the opportunity in the cases that it's selected to really address this question, because it's been quite obvious. The Burger King case, the defendant's contacts with the state of Florida were obviously closely related to the plaintiff's cause of action for breach of contract. So what I'm getting at is, if this is something that's really very clear in terms of there clearly is a relationship between the claim and the contacts, you really don't need to go on and on and on about the but-for test and the evidence test. You can say a little bit about it if you want to, but to write a page or two is probably not a good use of your time. All right, so let's say you conclude that yes, indeed, there is a relationship between the plaintiff's claim and the defendant's contacts with the forum state. That means that you are talking about specific jurisdiction. And I think for your purposes, it's probably very helpful to organize your answer the way that the Fifth Circuit formulated the requirements for specific jurisdiction in that Ainsworth case that we read, that was posted on the Twen site. And that was overall a three-step process. First, that minimum contacts by the defendant were purposefully directed at the forum state. Second, that there is a nexus between the defendant's contacts and the plaintiff's claim. And third, that the exercise of jurisdiction over the defendant be fair and reasonable. So I'm going to talk about each one of these in a lot more detail in the slides that follow. The second element here, the nexus, is the one that we just talked about in the last slide, and you've answered that question in the affirmative because you've ended up in the specific jurisdiction part of this whole analysis. So in the remaining slides, I'm going to focus on the first element here, the minimum contacts that are purposefully directed at the forum state, and then the third element, that the exercise of jurisdiction be fair and reasonable, or what are also known as the reasonableness factors. All right, so let's discuss the purposeful contacts requirement. This is kind of the touchstone of the specific jurisdiction minimum contacts analysis, is that you've got this list of contacts now that or potential contacts that you've kind of brainstormed. And now you need to go back and look at those contacts and ask, did the defendant purposefully establish these contacts with the forum state? And so the way that this was first phrased in the Hansen versus Stenkla case was, this is the defendant's purposeful availment of the benefits and protections of the forum state's laws. So these cannot be what the court calls random or fortuitous contacts. And importantly, these contacts are not going to qualify as being purposeful by the defendant if those contacts were established by the unilateral act of somebody other than the defendant. So, for example, in the World-Wide Volkswagen case, it was the contact, the potential contact of World-Wide Volkswagen was that it sold a car in New York, the car ended up in Oklahoma, and it exploded on impact, injuring the plaintiffs in Oklahoma. However, the court said that that was not a contact that was purposefully directed by the defendants. It was the result of the unilateral activity of the plaintiffs, the Robinsons, in driving that car to the state of Oklahoma. So you always need to be on the lookout for a contact that was created by the unilateral activity of someone other than the defendant. The World-Wide Volkswagen case and subsequent cases also talk about the idea of foreseeability to the defendant. And there's an important distinction here made by the court in that the foreseeability that is important to the due process analysis is the foreseeability to the defendant that this contact would lead to this kind of lawsuit in this forum. So it is not merely the foreseeability that if I go ahead and sell a car in New York, well, sure, it's foreseeable that that car might be driven to Oklahoma. But what was important to the court was, would it be foreseeable to them that they would end up in Oklahoma defending a products liability action? And the court, the majority, believed that the answer to that question was no. Okay, so those are your basic principles. And again, I mean, I said in class that I don't think this is really all that complicated, although that doesn't mean that reasonable minds, may not differ on the application of these principles. But the principles themselves are really fairly straightforward. It comes in the application in different situations that we start to feel like it's a little more complex. So there are several things that might crop up on a hypothetical, or of course in real life, that there's a case that sort of is closest to whatever your new factual situation is. And of course, in doing your analysis, you should focus, when you're really getting down to the nitty-gritty of your analysis, you should focus on the facts and circumstances of whatever Supreme Court case or cases are closest factually to your hypothetical fact situation on the exam. So you might have, for example, a stream of commerce situation. If that is the hypo, then you're going to want to focus on the World-Wide Volkswagen case and the Asahi case, and maybe mention the McIntyre case for what it's worth, which is nothing. Secondly, you might see that the defendant has property in the forum state, so the defendant owns property in that state. In that case, you might think about talking about Schaffer versus Heitner. In another hypo, you may see that the defendant has a contract with a resident of the forum state, usually the plaintiff. Well, this would bring up the Burger King case. It might also bring up the McGee case. And then we have the effects test from Calder v. Jones, which talks about the effects of intentionally tortious conduct in Florida being caused in being directed against a resident of California, and the harm being caused in California by the intentional conduct in Florida. And then we also have the idea of a website of the defendant that is, of course, accessible in the forum state, because websites are accessible anywhere. So I'm going to talk a little bit more about each one of these things. Stream of commerce. All right. Now, students have a tendency to apply the stream of commerce analysis in more situations than those to which it is truly applicable. So they over-apply stream of commerce. Stream of commerce is talking about a business situation where the defendant makes a product. Most paradigmatically, the defendant is going to manufacture a component part of a finished product. So, for example, in the Asahi case, the defendant Asahi manufactured a valve that was then shipped to Taiwan and put into another part of a tire, and that part was then shipped to California as part of a finished tire and sold and caused a motorcycle to have a blowout. So that's the component parts situation. We can also see the stream of commerce situation if the defendant manufactures a finished product and then ships its product to a middleman, such as a distributor, and it is the distributor who then ultimately sells the product to the consumer in the forum state. And that was the situation that we saw with both World-Wide Volkswagen, as it applied to, for example, Audi, and McIntyre, as it applied to the McIntyre manufacturer of that machine in the UK. And when you identify this situation, the question that the courts have the Supreme Court, the justices have split on and have never resolved is the question of, does the defendant's mere awareness that its product will end up in the forum state constitute purposeful availment of that state's benefits and protections? So remember that, the key concept here that we're trying to apply is, did the defendant purposefully avail itself of the state's benefits and protections? And so if you know that the defendant's part or the defendant's machine ended up in the forum state and was purchased in the forum state and caused injury to someone in the forum state, you might simply conclude that, well, the defendant purposefully availed itself of that state because its product was sold in that state. In the Asahi case, the justices could not agree on an answer to this question. None of the opinions in that case, which dealt with this specific question, garnered a majority opinion. So you had Justice O'Connor's part of this opinion, which was the plurality opinion. You had Justice Brennan's concurrence, and each of those opinions only had the votes of 4 justices. And then Justice Stevens had his own concurrence. Now, Justice O'Connor's opinion as a whole contained different reasoning of the court that went to the reasonableness of the assertion of jurisdiction over the Japanese company Asahi. And the court was unanimous in agreeing that in the circumstances of that case, the exercise of jurisdiction over Asahi would be unreasonable. But in terms of the part of the analysis that we are talking about now, which is the minimum contacts / purposeful availment part of the specific jurisdiction analysis, the specific application of purposeful availment to the stream of commerce remains undecided by the United States Supreme Court. So Justice O'Connor's plurality opinion answered the question that you see on the screen in the negative. saying no. A defendant's mere awareness of the fact that its product could end up in the forum state is not enough to establish the defendant's purposeful direction toward the forum state. So importantly, Justice O'Connor added that here are some things that the defendant might do in addition to just being aware that its product might end up in the forum state. Here's some things that the defendant might do that would indicate an intent or a purpose to serve the market in the forum state. Designing the product for the market in the forum state. Advertising in the forum state. Establishing channels for providing regular advice to customers in the forum state. Or marketing the product through a distributor who has agreed to serve as the sales agent in the forum state. So that would be Justice O'Connor's take on it. Justice Brennan, in his concurrence, believed that the answer to the question that you see on the screen is generally yes. He says, as long as a participant in this process, meaning the stream of commerce, is aware that the final product is being marketed in the forum state, the possibility of a lawsuit there cannot come as a surprise, nor will the litigation present a burden for which there is no corresponding benefit. So he would take a more liberal view of this question than Justice O'Connor. And Justice Stevens, speaking for two other justices, said that he believed this inquiry needed to take into account the volume of the defendant's product in the forum state, the value of the defendant's product, and the hazardous character of the components of the defendant's product. So there you have it. As far as Asahi, clear as mud. Now, as if Asahi were not bad enough, we now have the atrocious opinion of the McIntyre case, where once again we did not have an opinion from the Supreme Court that commanded a majority in its reasoning. So there you had a plurality which seemed to believe that the manufacturer in the UK needed to purposefully target the sale of its product in the state of New Jersey in order to meet the purposeful availment test. And the reason that I find this very problematic is that, let me back up and talk about the factual situation in McIntyre. So we have this manufacturer of this shearing machine who engages a United States distributor in Ohio to try to sell its machines anywhere in the United States. It was the exclusive distributor of this manufacturer's machines. And so the charge to its distributor was, just go ahead and sell these machines wherever you can. It didn't specifically say, and by the way, be sure you try to sell it in New Jersey, but it didn't not say don't sell it in New Jersey either. So, the implication is clearly we want you to sell these machines wherever you can, in any state you can. And so in that sense, it's unclear to me why that wouldn't be conduct that exactly comports with Justice O'Connor's suggestion that engaging a distributor to attempt to sell your product in the forum is not something that takes it beyond mere awareness of your product being sold in the forum to purposefully directing your product being sold in the forum. But again, the justices were split on this particular issue. There was no majority opinion, and as you saw, the Fifth Circuit in the Ainsworth case analyzed the question. They believed that the controlling opinion there would have been the concurrence by Justice Breyer, who in essence believed that there was no need for the court to develop any additional principles in that case because the answer was given by the application of pre-existing principles. So the Ainsworth's opinion in terms of what do we take out of McIntyre going forward is that McIntyre did absolutely nothing to change pre-existing law on stream of commerce. So what do you do if you get a question on this? Well, relieve yourself of the necessity to believe that there is a right or a wrong answer on this, or that there's going to be any kind of clarity in the governing law, because the answer is no and no. So what you would do is you'd simply, identify the issue, identify the question, and discuss the various approaches of the various justices and how, the case would come out under any of these approaches. Okay, so that was the hardest, the stream of commerce. Now, what if one of the contacts of the defendant with the forum state is that the defendant happens to own property in the forum state? Either it could be, a house, a real property, like I've got pictured here on the screen, or it could be something more intangible, like what was that issue in Schaffer versus Heitner? The defendants were deemed to own stock that was deemed, or they did own stock which was deemed to be in the forum state by virtue of a state statute. So here, just going back a little bit to the historical underpinnings of Pennoyer versus Neff, you'll recall that Pennoyer versus Neff believed that it was constitutional for the court to exercise in rem jurisdiction to the extent that the defendant owned property in the forum state, as long as the court did not exercise jurisdiction beyond the value of the property in question. And the implication of Pennoyer, as well as later decisions following Pennoyer, such as Harris versus Balk, was that there needed to be no connection whatsoever between the plaintiff's claim and the defendant's property that was owned in the forum state. And the continuing constitutionality of that proposition was considered in the Schaffer versus Heitner case because what, of course, happened in the interim was international shoe and the minimum contacts test. So Schaffer versus Heitner essentially held that if the defendant owns if the defendant owns property within the forum state, that is a contact, certainly, and you can consider it as a contact. However, in and of itself, if that's it, then that does not necessarily mean that you have constitutional jurisdiction over the defendant anymore. So you need to now consider the relationship between the plaintiff's claim and that property that is owned by the defendant. And if what the plaintiff is trying to get the court to do is to exercise quasi-in rem jurisdiction type 2, then Schaffer versus Heitner holds that this is no longer permissible, even though Pennoyer at one point said that it was. So just briefly to review, what on earth is quasi-in rem jurisdiction type 2? That is where the court attaches the defendant's property at the beginning of the lawsuit and attempts to exercise jurisdiction over that property up to the value of the property. But the property has no relationship to the plaintiff's claim. And so if that is your basic situation and there is no other means for exerting personal jurisdiction over the defendant in a constitutional manner, then that is not going to be enough anymore. All right, the third situation that might come up with respect to specific jurisdiction is having a contract with a resident of the forum state. And this, of course, the main case that we considered was the Burger King case. Another case that we considered was McGee versus International Life Insurance, Lulu McGee in California, whose son died and left her as the beneficiary of a life insurance contract. So Burger King said, sort of similarly to Schaffer, that you can certainly look at that contract as a contact of the defendant with the forum state, but that just because the defendant had entered into a contract with a resident of the forum state was not necessarily enough in and of itself to automatically establish personal jurisdiction. Instead, the court said that you examine all the circumstances around that contract, such as prior negotiations and contemplated future consequences, along with the terms of the contract and the parties' actual course of dealing in determining whether the defendant purposefully established minimum contacts within the forum. So you're going to look at the nature and extent of the contract itself. And finally, we have the effects test of Calder versus Jones, where a writer and an editor of the National Enquirer in Florida wrote and edited an allegedly libelous story against Shirley Jones, an entertainer who resided in California, about her alleged drinking. And she sued them for libel in the state of California, and the court held that the effects of the defendant's intentionally tortious conduct were felt in California such that the California court could constitutionally exercise jurisdiction over them. So the court emphasized that the story concerned the California activities of a California resident, that her career was centered in California, the article was drawn from California sources, the brunt of the defendant's harm was suffered in California. So in short, California was the focal point both of the story and of the harm suffered. Jurisdiction over petitioners is therefore proper in California based on the effects of their Florida conduct in California. Okay, so now we get to the other major branch of personal jurisdiction besides specific jurisdiction is general jurisdiction. And it is harder to establish general jurisdiction than it is to establish specific jurisdiction. So first of all, go back and remember that you're not going to even reach the question of general jurisdiction if the cause of action arises out of or is related to the defendant's contacts with the forum state. If that's the situation you've got, you're talking about specific jurisdiction. So you're only going to talk about general jurisdiction in any detail if you find that the plaintiff's claim or the plaintiff's cause of action does not arise out of the defendant's contacts with the forum state. So that's your prerequisite to even be talking about general jurisdiction. So the test, once you get into that realm, is fairly simple to state, perhaps a little bit harder to apply. And the test is that the defendant needs to have continuous and systematic contacts, sometimes called substantial contacts, with the forum state, such that the defendant is essentially at home in the forum state. So this was recently confirmed by the Goodyear case, where foreign subsidiaries of the Goodyear Tire Corporation had shipped tens of thousands of their kind of tires through Goodyear's distribution system that had ended up in the state of North Carolina, but that the actual tire that caused the accident in this case was not sold in the United States, had not apparently been shipped into the United States, and what was giving rise to the cause of action was a tire that allegedly blew out in France, killing the plaintiff's sons, and the plaintiffs then sued in North Carolina. So the court proceeded on the assumption that the contacts of the defendants, the foreign Goodyear defendants, with the state of North Carolina were simply the shipment of thousands of tires into the state of North Carolina that had nothing to do with the plaintiff's cause of action, which had arisen in France from a different kind of tire. So the question was, is that shipment of a bunch of, or thousands of tires into North Carolina enough to subject these defendants to general jurisdiction? And the court said no. With this, the principle of law being a court may assert general jurisdiction over a foreign corporation, meaning a sister state corporation or a foreign country corporation, to hear any and all claims against them when their affiliations with the state are so continuous and systematic as to render them essentially at home in the forum state. So remember that if you find that a defendant is subject to general jurisdiction in a state, that means that you could assert any cause of action in the world against the defendant in that state. So that's how extensive the defendant's contacts with that forum state have to be. And of course, in the Goodyear case, the court held that there was no general jurisdiction over the foreign subsidiaries of Goodyear. All right, so now you have come to the end of one of the major provisions of this analysis, namely, we've looked at the contacts, we've analyzed the extent and the nature of these contacts, either in the context of specific jurisdiction or general jurisdiction. We've already analyzed whether there's a relationship between the plaintiff's claim and the defendant's contacts. Now we reach the third major branch of the analysis, which is that assuming we do have the necessary level of contacts, is the exercise of the court's jurisdiction fair and reasonable? So these are sometimes known as the fairness and reasonableness factors, sometimes called the Gestalt factors. These 5 factors were first enumerated in World-Wide Volkswagen and have been repeated in many of the cases after that. And different cases kind of apply more to different factors. So these factors definitely apply to a specific jurisdiction analysis. There is some dispute as to whether these fairness and reasonableness factors apply to general jurisdiction. I believe that they probably should. And so I'm just going to say that if you believe you're proceeding under general jurisdiction, you should go ahead and apply the reasonableness factors anyway. So again, we have a theoretical point here at which you might be able to say, well, I've concluded that there are no minimum contacts, or I've concluded that the contacts of the defendant are not systematic and continuous. So I don't even think that we've established the purposeful contacts element of the personal jurisdiction analysis. Therefore, we just don't even need to go on to the fairness and reasonableness factors. Now, theoretically, that is something that might be a possibility. However, on an exam, or indeed in a real life briefing situation, you would never simply stop here. You would, if you truly believe minimum contacts have not been established, or continuous and systematic contacts have not been established, or whatever the test is, depending on which branch of jurisdiction you're proceeding under, then you would say, now, I've concluded that we don't have sufficient purposeful contacts. However, just in case the court disagrees, I'm going ahead and I'm going to talk about the fairness and reasonableness factors. So you're going to have a fallback type of argument here. Okay, so here's the 5 fairness and reasonableness factors. The first is the burden on the defendant. And this deals not only with the geographic distance of the defendant from the forum state, which of course is a consideration, but it also involves the idea of, if the defendant is a foreign company, or I guess individual, then in the United States they're dealing with an entirely different legal system, and that in and of itself is a source of additional burden to them. And that is what was mentioned by the court in the Asahi case. So while this is an important consideration, you do have to keep in mind what Justice Brennan said for the court in the Burger King case, which is that if we've gone ahead and established that the defendant purposefully established minimum contacts in the forum state, then the burden is on the defendant, and it's a very high burden on the defendant, to show that the burden of defending this suit actually is enough to prevent the exercise of personal jurisdiction. The second reasonableness factor is the plaintiff's interest in obtaining convenient and effective relief. This was a factor that was emphasized in the McGee case, even though the McGee didn't really call it that as such, but the plaintiff in McGee was, an individual person who was litigating against an insurance company in a distant state, and if the plaintiff had had to go to Texas to litigate her dispute, she might well have never been able to obtain relief from the defendant at all. So what is the plaintiff's interest in actually suing in this forum? Is there somewhere else the plaintiff could have sued that would be equally as convenient for the plaintiff? Third, we look at the forum state's interest in adjudicating this dispute. A lot of times this is a fairly easy one to answer in the affirmative, because if the plaintiff is a forum state resident, then the forum state is almost always going to have an interest in adjudicating the matter because it involves one of the forum state's residents. This was a factor that was mentioned by the Asahi court in holding that the exercise of jurisdiction over Asahi would be unfair and unreasonable. What the court in Asahi said was, look, the original plaintiff, Zurcher, who was a resident of the forum state of California, has settled out of this dispute. And the only people that are left in this dispute are two foreign corporations, a Taiwanese corporation and a Japanese corporation. So the court said the forum state of California has far less of an interest in this dispute than it otherwise would have. Now, the fourth and fifth reasonableness factors are less commonly applied and certainly less easily understood. The fourth factor is the interstate judicial system's interest in obtaining efficient resolution of controversies. So something you might consider there is where are the witnesses located? Where is the evidence located? If we don't allow personal jurisdiction in the forum state here, are we going to end up with two lawsuits instead of one? Just anything that the facts might suggest to you raise an issue of efficiency in the resolution of controversies. And the final reasonableness factor is the shared interests of the states in furthering substantive social policies. So for this factor, what you ask yourself is, first you go back and identify what's the plaintiff's cause of action here. So say it's products liability. So what's the substantive social policy behind having a products liability claim? It is to foster the manufacture and sale of safe products, right? We don't want a bunch of dangerous products floating around injuring people. And so you ask yourself the question, if we don't allow the forum state will that somehow harm the social policy that this claim is supposed to effectuate? So you could say that the decision in World-Wide Volkswagen, for example, went against this fifth reasonableness factor, because if what we're talking about is a products liability claim, but we're saying that we can't get personal jurisdiction over the retail seller of the defective product, the allegedly defective product, or the regional distributor of the allegedly defective product in Oklahoma when their product actually did end up in Oklahoma, then that's going to make the enforcement of a regime of producing safe products harder to come by. So the only case that I can think of offhand where the Supreme Court applied or kind of went into this last reasonableness factor is a case that we did not read in full, and that was the Colco case, where, and I'm not looking at the case in any book right now, I'm speaking from memory, so I'm hoping I'm getting this right, but Mr. Colco, it was another one of these divorcing couples cases, and it was quite similar to the Burnham case in that the Colcos were also a married couple that lived on the East Coast, and then they were going to get a divorce, and the wife moved to California. In the Colco case, however, what happened was the kids originally stayed with their dad, and then one by one decided that they wanted to go live with their mom in California. And so one by one they were shipped off to go live with their mom. And then the mom filed a child support action in California against Mr. Kolko, who was still on the East Coast. Now, unlike Burnham, Mr. Kolko did not actually go to California, and he was not actually served with process in California. So we didn't have kind of an easy way of getting jurisdiction over him in California. And so the wife argued that personal jurisdiction should be upheld over Mr. Kolko because he had acquiesced in his children going to the state of California. So now the wife, was incurring more expenses on behalf of those kids because they were there, and the cause of action for child support arose out of those contacts. This is the wife's argument. The court held no, personal jurisdiction is beyond the Constitution in this case, and one of the reasons that it gave was that Mr. Kolko was kind of a good guy in that he acquiesced in a change in the custody situation of these kids. And we want to encourage people to resolve their custody disputes on an amicable basis. And if we hold that there is personal jurisdiction over him on these facts in California, then in the future people might think twice about just letting their kids voluntarily change custody and go live with their mother. So that would be an example of a substantive social policy that the court took into account in determining the personal jurisdiction question. So that finally brings me to the end of this run through personal jurisdiction, and I would ask you to please go ahead and fill out the certificate that you have listened to this video. That certificate is on the Twin site, and you need to submit it on the Twin site. And this lecture will count in place of the last scheduled class of the semester, which would have been the Monday of the week of Thanksgiving, and which I have now canceled. So this is the substitute for that class. So have a great day or a great evening, and I will see you soon.